Good afternoon, everyone. My name is Mark Cardy, and welcome to Legally Speaking, a criminal law web series presented by Aitken Robertson Professional Corporation. My name is Mark Cardy, licensed paralegal with the firm, and your host for today's episode. A reminder for everybody watching that this series does air the first Thursday of every month on our Facebook Facebook page for Aitken Robertson. As well as our YouTube channel, which is www.youtube.com/AitkenRobertsonLaw. The episodes stay on those channels, so if you miss a live stream, don't worry. There's going to be, they posted live after the fact, okay? So keep an eye out for any other episodes. If you want to catch up on some of the previous episodes, please visit our YouTube channel. My guest today is Caryma Sa'd. Caryma is a Toronto practicing lawyer in areas of criminal law as well as landlord and tenant law. She is a trusted source and frequently called upon by the media, particularly on her focus on the legal issues revolving around cannabis. Today, Caryma and I are going to be discussing cannabis use by tenants in rental properties, as well as the rights and responsibilities of landlords when it comes to cannabis on the premises. And we'll also discuss how legalization will fare against the landlord and tenant laws within Ontario. Caryma, welcome to the show. Thank you for joining me today.
Thank you for having me.
Yeah, so we have an exciting episode for everybody involved, and let's just get right into it. So, smoking bans in leases. It's not uncommon for there to be a clause in a contract that you're signing indicating that you cannot smoke on the premises. Now, will this be a hurdle for residents who want to use cannabis?
So if a tenant has already signed a lease and it stipulates no smoking, generally that will be interpreted to include any substance. So if there's already that provision in place and that agreement has been made, whether it's tobacco or cannabis, it may be difficult to persuade the landlord-tenant board that you're on side.
Now, if it's not outright stated, then the answer, I guess, would be no, that they cannot consume cannabis if they have a condition for just smoking. Is that correct?
I mean, so some provinces have taken an approach where they've made it clear, and they say, where it says tobacco, we also mean cannabis. And Ontario hasn't done that. So it's a little bit murky, but I think, when push comes to shove, if your lease says no smoking, you're probably not going to be able to smoke cannabis there either.
So,
but if a lease is that's totally different.
Yeah. Now, would it be easier on landlords if they specifically specified no cannabis smoking, or does it really matter if it were to get to the landlord and tenant board?
I mean, I don't know that it would be determinative one way or another. Obviously, the more specific you can be, the better. But you would perhaps have some questions to answer about, why cannabis specifically, if you are allowing to smoke.
Okay. Now, what if an individual has a medical cannabis license? Now, would that supersede any lease agreement that may be in place?
That's a very interesting question. And there, like many things in law, there is no clear answer. So depending on how that lease is interpreted, certain members would say, no, you made an agreement and it is what it is. And others would take a more sympathetic approach. And a medical license would fall under the jurisdiction of the Human Rights Code. So if you were being, let's say, evicted for smoking and you have a license to smoke, I think that you do have some protection in your corner, but there may, a solution could be that you're vaping instead of smoking, or you're smoking on your balcony, not inside, or maybe you're consuming in a different way.
Now, just based on what you said, would vaping have to be written explicitly into the lease agreement, the no vaping? Just because you see it now, I mean, you're going into a building or like a restaurant, and they actually have the no smoking, but now they also have that no vaping sign as well. If it's not articulated in the lease, can individuals vape in those rented properties?
So the Smoke Free Ontario Act takes a pretty broad definition of smoking, which does include vaping. So, when we interpret no smoking, It's not too much of a stretch to say no vaping either. However, they're quite different in the sense that smoking, I think, produces a more lasting odor and effect, whereas vaping tends to evaporate pretty quickly. So, again, it's not perfectly clear cut. And if a landlord wants to ban everything, that would need to happen at the outset, and a tenant would have to agree.
Now, is it within the landlord's power to refuse to rent to someone with a medicinal cannabis license?
Aha. So there, you could make an argument that there is discrimination on the basis of disability, if that ends up being the sticking point. Now, those cases can be hard to prove one way or another. So you would really need a landlord to why I'm refusing your lease. So it's tricky in that sense to prove, but absolutely there could be a human rights complaint if a tenant has a sense that the reason they got denied an application was because of their medical needs.
Okay. Now, what happens if a tenant is in a lease but receives maybe a medicinal marijuana license, halfway through their term? Do they have to articulate that to the landlord? What are the responsibilities of a tenant at that point in time?
So you're dealing with competing interests here. On the one hand, you have your privacy interest and not wanting to necessarily disclose what type of medicine you take or why or when or in what form. But on the flip side, if you have a lease that doesn't allow for smoking, it may be in the tenant's interest to establish a line of communication to explain and say, look, I know that this is what's on the lease, but here is how my circumstances have changed. Here's what I propose to do, and then work together, establish, as I say, some dialogue and some mutual understanding. Doesn't work in every situation. This is sort of the ideal best practice where you have a reasonable tenant and a reasonable landlord, and that isn't always the case. So it's very much a fact by fact circumstance. But I would say that to best protect themselves, it would make sense to put in writing what the needs are and how an accommodation could be provided. And then the landlord, the ball would be in their court from there.
Okay. And let's say a lease is signed, prior to October, prior to the legalization of cannabis, and say the lease, did not actually stipulate, no smoking. Can landlords change an agreement to prohibit cannabis use midterm?
So my position, and this is my stance on it, so different lawyers may have different interpretations. I think it's very difficult for a landlord to unilaterally change a lease. And what I mean by that is a lease agreement is two sides saying, okay, this is what I agree to, this is what I agree to, and there's what's called a meeting of the minds. And so for one side of that contract to say, you know what, by the way, here's this extra clause, that's not something that would necessarily hold up in court. So my instinct is that if a landlord does want to, going forward, ban cannabis, that's a discussion that needs to happen with the tenant. It can't be sort of imposed in a dictator way. And if a tenant isn't on board with that, the landlord might not have much recourse.
Now, in that situation, what should tenants know about their rights or their ability to challenge the legality of the landlord trying to change the lease midterm?
So the main threat to a tenant, would be the threat of eviction, right? So if we step back and we think about under what circumstances can a landlord try to evict a tenant, there's a couple that I think would be relevant to cannabis. Let's focus on smoking for now. So if there is interference with others, or if there is damage to the property, those are two circumstances where a landlord can try to evict. So if a tenant smoking is bothering other tenants or creating any sort of damage, then a landlord could move in that direction. So tenants need to be mindful that even if their lease doesn't specify no smoking, they still need to behave in a way that isn't interfering with others and isn't creating damage.
Okay. Now, does the type of rental or the type of lease matter when it comes to these sort of things?
I mean, I guess I can take that question in a couple of different ways. There, as of April of 2018, there is a standard lease, and tenants are entitled to have that lease. So if you don't, and you've signed a contract after April 2018, that's something that you should look into. And the standard lease does have a special box to tick for smoking, no smoking, and it also has an area for other kinds of side agreements. So something could potentially be written into there that would prevent a tenant from smoking. If we're dealing with an older lease and it's silent on the issue, I would revert to my position that, without an agreement from the tenant, a landlord can't one-sidedly say, here are the new rules, abide by them or else.
Okay, now, what if the lease, how important is wording when it comes to leases? So let's say my lease says, no smoking or usage of cannabis, and obviously cannabis can be consumed in edibles. Would that be breaching the lease? Because the word usage doesn't necessarily stipulate just smoking. What would the effect be on an individual who may be consuming edibles in a rental unit where it actually says no usage as opposed to no smoking of cannabis?
I mean, the first question is, how does anyone find out and what is the basis of a complaint, right? So at least can say what it says, but, short of there being an actual disturbance or something like that, it's hard to enforce. That's my just sort of off the cuff. But let's say, no usage, and you do want to create edibles at home and you're using your stove for that purpose, and it stinks and it's bothering other people, we circle back to, interference as a potential ground for eviction. So whatever your lease says, you got to be careful about that.
Okay. And what happens in situations where there's no official or written lease? And what are the rights and responsibilities of a tenant in that particular situation?
So if there's nothing in writing, we basically defer to the legislation. And landlord and tenant relationships are governed by the Residential Tenancies Act. So, the guiding principle, not to sound like a broken record, but a tenant has the obligation of not interfering with others, not causing damage, and landlords have the responsibility of basic repair and maintenance and not harassing or interfering with or obstructing tenants in their own lawful activities.
Okay.
So stepping to your question about, no usage, that were to come before the board and there is no real complaint, it's just a matter of, well, technically he's not supposed to use it at all, and I'm taking issue with that. I think that what would need to be answered is, what right of intrusion does a landlord have in that regard? Because certainly you don't see sort of no alcohol permitted in a lease, and that's not something I think that would stand up, because once you're in your home, you have various privacy interests and the right of reasonable and quiet enjoyment. So you do your thing. If you're not bothering anyone, what's the problem?
Okay, it's good answer. I like it. So let's say an individual is in a residence and maybe there's a complaint of a neighbor that they smelled some cannabis, or they smelled some smoke, and they notified the landlord. What happens if the landlord shows up without giving the tenant notice to inspect if there's any breaches to the lease, such as smoking or consuming cannabis in that rental unit?
So short of there being an emergency, and emergency isn't that broadly defined, it's more like fire or flood, or if the tenant consents, a landlord absolutely cannot just show up and do an inspection. There are very specific requirements for notice. It has to be in writing, has to be at least 24 hours in advance, there has to be a purpose, and there has to be a time frame, and it can't be a broad time frame. It has to be, you know, maybe a couple of hours, not more than hours, as a general rule, right? Everything is fact dependent, but as a general rule. So if a landlord gets that complaint and they show up unannounced, that they could actually land themselves in hot water if a tenant makes a complaint. So it's important for landlords to be diligent in following up with these types of investigations, but they have to be mindful of their own obligations and responsibilities under the Act. And that right to reasonable enjoyment and quiet enjoyment is very sacred.
Okay, so let's say I'm a landlord and I show up at my rental unit, or I'm in an apartment building, and I smell cannabis smoke outside the door or outside the window, and I know that they're smoking inside. What would a landlord do in that situation, or what should they do?
Best practice would be to get something in writing. Always establish a paper trail. That's, you know, advice for both landlords and tenants. So if you are a landlord and you make this observation, you might want to send an email or make a note saying, you know, on this day at this time, I was outside your window and I noticed a whiff. You know, friendly reminder that your lease says no smoking. If this problem persists, you know, there may be penalties or there may be consequences.
Yeah. Now, what about growing your own marijuana in a rental unit? What would be a tenant's responsibility, and how should a landlord react? If should it be written in the contract as well, or the lease, sorry, you know, no growing of cannabis, or would that kind of fall under the, you know, usage of cannabis or smoking of cannabis?
So the growing of cannabis at the federal level, it's been decided that, you know, tenants have a right, or sorry, not tenants, households can grow up to 4 plants, okay? And that's at the federal level. Now, housing laws are made at the provincial level, and there's nothing that's changed in the Residential Tenancies Act that says, you know, this is a permissible thing to ban. And we do have, you know, laws that say you can't ban pets. We don't have anything that says you can't ban pot. But we also don't have anything that says you can ban pot. So it would, I think, go to the lease and what was agreed upon at the time. And I think, you know, landlords and tenants both should be respectful and try to cooperate. So no one wants a situation where a grow has now caused water damage or has short-circuited the building's electricity, or it's stinky. Like, nobody, that's not beneficial to anybody. So I think that tenants should be mindful of what sorts of precautions can I take to ensure that I'm not going to be damaging anything or causing any interference. So things like a tent that is keeping the plant separated from the ground, ensuring that you are monitoring the humidity, a carbon filter perhaps to reduce smell, lights that aren't going to overheat. Those are all simple measures that a tenant can take to minimize the impact. And, you know, it's not much different than growing tomato plants at home. And for a landlord's part, you know, if it is something that they're concerned about, a wise course of action might be, look, if you are going to go, I'd like to be able to inspect your setup and to make sure that everything is up to par, that you're not using sort of outdated equipment that could cause trouble down the line. Again, a good open line of communication will solve a lot of problems before they even materialize. So that would be my general suggestion. If you have a landlord-tenant relationship that's a bit more contentious and heated, and the tenant is reluctant to disclose or be open with the landlord, then they really need to be mindful about taking precautions, not causing damage.
And can a landlord flat out say no growing in the rental unit? Or you don't have to answer.
I mean, so at the beginning of a lease, in theory, and there's not really any case law on this point because it's such a new area of law. And you know, to be quite honest, I'm not sure how that would hold up, because I have difficulty imagining a lease where, you know, you can't grow your basil, and that's something that you could be evicted for. So it's hard to say, because this is a brand new topic that hasn't really been broached. But as a, you know, sort of general rule, if it's in the lease and it's a side condition, and it's permissible, it's not a illegal condition, you know, landlords and tenants can make those kinds of arrangements.
Okay. Now, what should students know? Obviously, you know, a ton of people go to school, you know, university and college, and you know, they stay in the dormitories. What should they know about, you know, internal school housing as well as off-campus student housing?
So internal school housing is a bit tricky, because the Residential Tenancies Act doesn't necessarily apply. It's a unique type of housing situation, and it may fall under an exemption. So students in that case would have to be respectful of whatever rules are being set out by the institution. And you know, that may well include no growing, no smoking in your unit or your room. So that's part of the answer. For off-campus housing, assuming it's a regular landlord-tenant relationship, the same rules apply. However, the federal rule for 4 plants per household, it's a little bit unclear what a household is. So if you have, say, roommates, and you're all in one building dwelling, and you're all on the same lease, you know, you may be 4 separate individuals, but you can't necessarily have 16 plants. And again, that is something that has to be determined. There hasn't been much interpretation of that law. You got to be mindful of what's happening.
Okay. You might not be able to answer it, but let's say I rent out my basement. I have a basement apartment, and you know, I want to make a little bit of income to help pay for my mortgage. When it comes to growing, would that be a separate household, or is that still considered the same dwelling?
Hard to say. I mean, if there is a separate entrance and you have like sort of your fire protections and so on and so forth, then arguably it's a separate household. But it's the same building, so hard to say. I mean, you play to the whistle, I guess, and then if there's a problem, you know, you deal with it when the time comes. But you know, that's maybe not the most helpful.
Yeah. Well, here's one final question. Let's say I'm renting a property, and you know, the utilities are included, and I start growing some plants, increasing obviously the cost of the utility for the landlord. Would the landlord have any course of action that could be taken against the tenant in that type of lease?
I mean, it depends. If we think about a situation where maybe the tenant uses a hair dryer a lot, and that takes electricity, or space heaters or anything else, you know, is there really recourse? You know, you might have to renegotiate how that is set out, and perhaps an above guideline increase. You know, those are tricky applications for a landlord, so I'm not sure that would be the most logical course of action. But you know, there's very little that can't be solved with a good, heartfelt conversation. And I think, you know, if you have a reasonable tenant, a reasonable landlord, and the landlord says, look, you know, here are the bills, here's the data, here's what's happening, can you help me out? I think that, you know, that would be a good starting point.
Okay. Anything else you want to touch on? We are getting close to the end of the episode.
I mean, I think that we've covered a lot of ground. One thing I would add is that medical patients do have extra protections. And even if there is some uncertainty about whether that supersedes the lease or not, you know, I've had situations where a landlord has tried to evict a medical patient who was growing in their household. And in that circumstance, the eviction failed because the tenant was able to show all of these measures he took to be diligent about preventing any sort of damage or interference with anyone. So, you know, we circle back to those fundamental principles: quiet enjoyment, reasonable enjoyment, no interference, no damage, and, you know, everything should be gravy after that.
Okay, that's a great point to leave off on, Caryma. Thank you very much for joining me today. To learn more about Caryma, you can visit her website at SAD or sadvocacy.com. So that's SADVOCACY. I'm not sure if that's a play on your last name or not.
It's a mouthful, and it is. So Sadvocacy. But yes, all the letters sound the same. So what a nightmare.
So sadvocacy.com. So SADVOCACY.com. Again, thank you very much for joining us today, Caryma.
Thank you for having me. It's been a pleasure.
Okay, not a problem. Just a reminder that all episodes do air live, but are also available to watch free anytime on our Facebook page or on our YouTube channel. Please follow us on these particular social media applications, and they'll give you a chance and set reminders that also receive alerts when the show is about to go live. I am Mark Cardy from Aitken Robertson Professional Corporation, fightthecharges.com. Our website is on the screen. Oh, screen this way. Sorry, reverse. Yeah. We want our viewers to get the most out of this show. We strive to educate people and provide helpful resources. Make sure you check our social media feeds. Make sure you check out Caryma's website. I'm sure she is on social media as well. You know, just do your due diligence. You know, if you're renting a property and you consume cannabis, just make sure you know what your rights and responsibilities are. Replay this episode if you don't have a general idea, or maybe tell your friends to watch the episode on YouTube. Aitken Robertson does also have quite a few blogs posted on our website. You can visit www.fightthecharges.com. This show will also be posted there. Please remember that none of the information discussed today should substitute professional legal advice. Please contact myself or a lawyer at the firm, or Caryma, if you have any questions and you think that you may need a lawyer to assist you through you know, some troublesome times, if you will. To learn more about the services we offer, you know, visit fightthecharges.com or call 1-800-668-1657. Caryma, one final time, thank you very much for joining us today. That's our episode, folks. Legally speaking, the next episode will air April 4th. I'm Mark Cardy from Aitken Robertson. Take care.